Losing a loved one is never easy. In the days and months that follow, emotions run high, and the process of finalizing their affairs can feel confusing, overwhelming, and daunting. Hi, I'm Patrick Roth, the owner of Roth Elder Law. At Roth Elder Law, we believe that when a loved one passes away, you should be able to focus on healing and cherishing their memory, not feeling overwhelmed by the legal and financial responsibilities which they've left behind. If you've been named as someone's fiduciary, whether it's an executor, a trustee, or an administrator, you're tasked with the enormous responsibility of settling their estate or trust. It's an honor to be trusted with this role, but it can also leave you feeling stressed or uncertain. Let me share with you a story about a client that we will call Sally. When her husband passed away, Sally was left with the responsibility of serving as a trustee for their revocable trust. Although she and her husband had planned ahead, Sally felt overwhelmed and unprepared for the complicated estate and trust administration process. Her husband had always managed the finances, so she was suddenly faced with making decisions in an area that she knew very little about. When Sally came to Roth Elder Law, she told us she wasn't just looking for someone to take over. She wanted a firm that would guide her through the process and involve her in the decisions and respect her wishes. By the time we were done, not only had we helped her settle her husband's affairs, but Sally also commented that she felt stronger and more independent as a result of our work together. If you've been named as a fiduciary, it's important to understand that this role comes with a significant amount of legal and financial responsibilities. Many people don't realize that they are not required to hire the attorney who drafted the will or the trust. And in some cases, it may be better not to, especially if that attorney doesn't limit their practice to estate and trust administration. Why does this matter? Because if the estate or trust isn't handled properly, you, as the fiduciary, could be held personally liable. For example, there is a priority to expenses. If there aren't enough assets to pay all of the valid expenses, there is a specific order in which they must be paid. If you pay them out of order, you may be required to cover any shortfall yourself. Early distributions. If you distribute assets to the beneficiaries too early, and there are still remaining expenses, you could be personally responsible for those costs. Protecting the estate or trust assets. If the estate or trust assets lose value because they aren't properly secured or managed, you could also be held liable for that. These are just a few examples of how complex and high stakes the process can be. That's why having the right attorney to guide you is critical, not just to protect the estate or trust, but to protect you as well. At Roth Elder Law, we protect whom and what you love by providing compassionate guidance during one of life's most difficult times. Our approach isn't just about completing tasks. It's about supporting you and your family so you can focus on grieving and healing. If you've been appointed as an executor, a trustee, or an administrator, and you need to help settle a loved one's estate, call us today. We'll take the burden and guesswork out of what needs to be done when a loved one passes away, so you can focus on what truly matters, honoring their memory and moving forward with your life.